All right, we will call the meeting to order for February, and we thank you all for being here. We'd like to call on Pastor Dana Fruits from First Presbyterian to do our invocation for us. Thank you so much.
Thank you. Good evening. I'm thrilled to be here tonight. So many times it didn't seem to work out, so thank you for the invitation. I would like to take advantage and just promote our community breakfast, which is this Saturday at the church, and we will be benefiting the Dragonfly House. So, as we like to say, let me pray y'all in. Let's pray. Gracious and loving God, we give you thanks for the gift of this beautiful day. Lord, we give you thanks for the gift of community. We give you thanks for the gift of those you have called into leadership for our community. We pray, God, that you would fill them with your spirit, that you would guide and direct and correct them, that they would remember their call of being servant leaders. Again, we thank you for this community. We thank you for the gift of your love. And we make this prayer in your name. Amen.
Amen.
Thank you.
Is Mr. Scott here? Okay. We will now have our pledge, and I tell you what, Brent, will you lead us in the pledge?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you so much. We adapt as we go here. Ethics and conflict disclosure, Mr. Vogler.
Thank you, Mr. Chair. Pursuant to North Carolina General Statute 168-86 and the Davie County Code of Ordinance adopted December the 2nd, 2019, I'd ask each of you before you adopt the agenda if there's any actual, potential, or perceived conflicts of interest with respect to any matter on the proposed agenda which will come before the board tonight for a vote. If so, please speak up now. Let the board know at this time before the agenda is adopted. Mr. Chair, seeing no one speak up, I conclude there's no actual, potential, or perceived conflicts of interest by any board member.
Thank you, Mr. Vogler. Before we adopt the agenda, I need to see if I could graciously get a motion from someone to remove item 14, closed session. We do not need a closed session tonight.
I make a motion to remove item 14 from our agenda.
Do we have a second?
Second.
Okay, thank you, Mr. Reniger. All in favor? Uplifted hand. Okay, thank you so much. Now, could we have a motion to adopt the amended agenda?
I make a motion we adopt the amended agenda.
Ms. Finney, and do we have a second?
Second.
Mr. Reniger, all in favor? Uplifted hand. Okay, thank you so much. Okay, we'll go to item 6, public hearings. Mr. Vogler, are you giving us rules on public hearings, or are we rolling right on?
I will give you a short synopsis of those rules. As Johnny comes up, Johnny can come on up, though. This is just on public hearing. When you come up, if you come up during the public hearing, you need to state your name so that Madam Clerk can get your full name and be on the record. You can talk with regards to what is on the public agenda, not something outside of the public agenda. That's just a very brief synopsis.
Thank you so much. All right.
So, ready for me now?
I'm ready for you now.
So, tonight we've got the evaluation of system development fees that is mandatory for us to evaluate every 5 years. And with us, we've got Elaine Bastis from Raftellus. Raftellus is a registered municipal advisor within the meeting. So, I'll let you go from there.
Thank you very much. Good evening. Thank you for having me. As Johnny mentioned, our firm was engaged by the county to calculate system development fees, so I wanted to kind of walk you through the calculation and answer any questions you may have. And I'm assuming. Okay. Yep, okay. So system development fees, these are the one-time charges that are assessed against new development. So that's what we're talking about here, is if you think of the construction of a new home, for example, it is the fee that's paid by that new development for the facilities that have been built to provide either water or sewer infrastructure. So that's what a system development fee is for. The impetus of the study, there was legislation that was passed in 2017 for the ability for cities and counties, municipalities to be able to charge these fees. That law was signed into law on July 20th of 2017. It sets forth a process that we're going to walk through, and it requires that the study be updated every 5 years. So that's where we are at this point. It's a requirement that the county update the study that was last performed 5 years ago, and that's what we have done. And there have been revisions that have been made to the legislation since then. So in order to adopt the fees, you have to engage a financial professional to conduct the calculation. We then have to document the analysis in a written report that gets posted on your website for 45 days to allow for any public comment during that period, written public comment. If there is any written comment, we would address it. There were no written comments that were received during those 45 days. And then after the 45 days, you can conduct a public hearing, and then you can adopt the fees and publish them. The legislation allows for 3 methodologies to calculate these system development fees. The one that we chose is the buy-in approach, and the reason for that is because the infrastructure system has already been built, and so we looked at the assets that have already been built, and that's what the calculation is based on. It's based off of the fixed asset records for the infrastructure in the East Davie system. What we do is we look at the fixed asset records for that infrastructure. We escalate it to today's dollars, but reflect the fact that it has reflects depreciation. We then have to take a debt credit, as stated by the legislation, because there's outstanding debt on the infrastructure in that area. We take a debt credit, we derive a net system value, so that's the value of that sewer infrastructure. And then what we do is we divide by the system capacity, and you get a unit cost of capacity. So what we've calculated is $5.12 per gallon per day for the sewer infrastructure in the East Davie system. And the way that you currently assess it is based on the North Carolina guidelines for sewer, which was recently modified, where it's 75 gallons per day per bedroom. It gives you basically the gallons per day for either residential use or commercial use. And so what you do is you take that gallon per day for whatever, commercial establishment or residential establishment, and then you multiply by that $5.12 per gallon to give you what the system development fee is for that specific new development. And so that's what you can see. What we've calculated here is kind of a sample of whether it's a 1-bedroom or 3-bedroom, and gave an example if it's, for example, a restaurant, how you would use the state's guidelines with this new $5.12 per gallon per day to come up with the system development fee. Any questions that I can answer?
Just one. Go back one more slide.
Sure.
Please. Yeah, your 2 million, that's the total capacity of the system. Why wouldn't you use the denominator, what's left?
What we do, we've put this on a gallon per day basis for all users, because over time, that's going to change, how much capacity is left. So the way that we like to look at it is we look at the total infrastructure that's been built by the actual capacity that that provides to get a cost per gallon per day that reflects more equity in the system for those that have been on the system and those that will be connecting to the system.
Gotcha. Okay, thank you.
Sure.
Other questions? Okay,
Thank you.
thank you. Do you need any action from us, or we're in a waiting period on this? Okay, all right. Okay, all right, Mr. Vogler?
Chair has announced this is the day and hour of the public hearing in North Carolina, pursuant to North Carolina General Statutes, Davie County Court Ordinance for amendments to the system development fees for East Davie wastewater system for Davie County. It's been due public notice given pursuant to the requirements of North Carolina General Statutes by way of due publication of notice of public hearing in the newspaper of general circulation in Davie County. Clerk to the board has attached affidavit showing the publication of said paper. I would ask all who wish to comment at this public hearing to come forward now, state your name, and then comment on the proposal. Mr. Chair, seeing no one come forward, I would now turn the public hearing back over to you as board chair to close the public comment section of this public hearing, provide the board the opportunity to discuss among yourself what, if any, action you wish to take.
Okay, do I have a motion to close public comment? So moved. Mr. Poindexter, do I have a second?
Second.
Mr. Schoaf, all in favor? All right, and do we have a motion?
I make a motion to approve the 5-year evaluation development fee study as presented.
Thank you. Mr. Renninger makes the motion. Do we have a second?
I'll second.
It's Finney second. Any other discussion? All in favor? Okay. All right, ordinance change, item 3.
So this adjustment to the ordinance is for adjustment of overcharges. So I want to touch on some of the key reasons for this adjustment. Is currently the way this ordinance stands is we adjust one bill per customer per year. We're only billing 6 times. So with us billing every 2 months, this leak could leach from one billing cycle to another. So we would like to change that to where we can adjust it per event, per leak, instead of one bill per year. Some other highlights of this is we can adjust the sewer off of it. So if this is leaking in the yard and they bring us something, or we go out and visit with the customer and notice that it's leaking in the yard, we can adjust all that sewer off instead of just a portion of it. And then I guess the last thing is this is just more customer based. Now that we've got the technology that we can go out and we can look at these meters and we can see the dates and times, we can help them out a little bit more when they get these leaks.
Any questions, Johnny? Okay, Mr. Vogler?
Chair has announced this is the day and hour of the public hearing pursuant to North Carolina General Statutes and Davie County Code of Ordinance for the amendment to the Water and Sewer Ordinance Use Agreement or Ordinance here in Davie County. There's been due notice given pursuant to the requirements of North Carolina General Statutes, Davie County Code and Ordinance by way of publication in a newspaper with general circulation in Davie County. The clerk of the board has attached the affidavit showing the publication in said paper. I would ask all who wish to comment this public hearing now to come forward, state your name at the podium, and then make your comments. Mr. Chair, seeing no one come forward, I would now turn the public hearing back over to you as board chair to close the public comment section of this public hearing, provide the board the opportunity to discuss among yourself what, if anything, you wish to do with regards to this matter.
Thank you, Mr. Vogler. Do I have a motion to close the public comment?
So moved.
Ms. Finney? Mr. Poindexter, second. Any discussion on this? All in favor? Okay. All right. Do we have a motion on item 3?
I make a motion that we approve the ordinance change as Johnny has described.
Okay, do we have a second?
Second.
Mr. Schoaf. Any discussion or questions, further questions for John? Okay, all in favor? Any opposed? All right. Item 4, ordinance change, Recreation and Parks Code of Ordinances.
Good evening, Mr. Chairman, Commissioners. Two amendments before you tonight are in our current Code of Ordinance, Davie County Recreation Park Code of Ordinances, Section 95.065, talking about parking and traffic. Item 7 will include the prohibition of semi-tractor trailer trucks on park facilities, with the exception of load-in and load-out on department-authorized equipment. And the most notable is Section 95.073, which deals with enforcement, i.e. banishment, making changes pertaining to banishment, which includes that department staff and county law enforcement may banish violators from 30 days up to 5 years. Anything exceeding 5 years up to 10 years requires a Recreation and Park Advisory Board approval. Anything that is more permanent, 10 years and beyond, would then go before you as county commissioners. From that, department staff, county attorney, county manager reviewed said amendments and were unanimously approved by our advisory board on December 12, 2023. Prior to any public hearing, I'd be glad to answer any questions you may have.
Any questions? Thank you, sir. Mr. Vogler?
Chair has announced this is day and hour of the public hearing pursuant to North Carolina General Statutes and Davie County Code of Ordinance of amendments to the Recreation and Park Ordinance of Davie County. It's been due notice given pursuant to the North Carolina General Statutes, Davie County Code of Ordinance by way of due publication of notice of the public hearing in the newspaper general circulation in Davie County. The clerk to the board has attached affidavit showing publication in said paper. I'd ask all who wish to comment at this public hearing to come forward to the podium, state your full name for the board, and then comment. Mr. Chair, seeing no one come forward, I would now turn the public hearing back over to you as board chair to close the public comment section of this public hearing, provide the board the opportunity to discuss among yourself what, if any, action you wish to take with regards to this matter.
Mr. Vogler, do we need to get you any water?
I'm fine. I got some. Might take a swig in a minute.
All right. Do I have a motion to close the public comment?
So moved.
Ms. Finney, we have a second. Mr. Poindexter, any other discussion on that? All in favor? All right. Now, do we have a motion on the change?
I just have a question
Please.
on the banishment for unbecoming acts. The 5 years is a long time. Was there ever any thought of, I mean, they need to be punished, that's not my point, but, you know, maybe giving them a year, and then if they violate it, then a super ban, maybe 5 or 10, or expulsion?
Those are on either first time or multiple offenses, so yes, it depends on case-by-case basis within our staff. We'll look at that on a case-by-case basis. Depends on how egregious the violation of the ordinance. They have to violate an ordinance to be able to serve some banishment. We have never gone over beyond except for what's before you in consent agenda tonight.
Thank you.
That answer, Terry. Okay. Any other questions? Do we have a motion?
I make a motion, we approve the ordinance change.
Okay, Ms. Finney, do I have a second? Second. Mr. Reniger, any other discussion? All in favor? Okay. Thank you so much. Item 5, ordinance change, Davie County Fire Rescue and Protection.
Commissioners, thank you for having me. The original fire protection ordinance was written and passed back in May 3rd of 2021. Since then, we've undergone some changes departmentally. I'm now my own director, not only over the fire marshal's office, but emergency management. And so everything that you see in your packet just has everything that the nomenclature changes. So who I report to, and then as far as who's the authority of this ordinance, that's solely our office now, and speaking with other departments and directors that did have a play in it in the beginning. Other than that, there are no changes, so it's mainly just defining that Mr. Barnett is who I report to and that we are the sole enforcers of this protection ordinance. And I'm open for any questions if you have any.
Any questions?
I have some.
Please.
Yes, ma'am.
So Cameron, you are our only emergency management coordinator now? Because at one time, were you and Joseph tag teaming that for a little while?
Yes, that is still correct, yes.
So you-
We do have a contingency plan.
Okay, that was going to be my next question. Do you have an assistant or a backup? Because you are entitled to a vacation once in a while, so.
Sure, yeah. So without getting too far off topic, I've been talking with Ed and developing our EOP, and we hope and plan to present you guys at a later date with a emergency management ordinance.
Okay. And then, under fees, cost, and penalties, where it says initial inspection of permitted work, upon initial inspection of permitted construction or operation, comma. It doesn't finish the thought. So what upon initial inspected of permitted construction work is? Does it go to your fee schedule, based on your fee schedule that we approved last year?
That's correct, yes, ma'am. So used to, we had, for a lack of better terms, give you a chance, we'll give you a chance, we'll give you a chance, we'll give you a chance. And that just wasn't productive. So during budget last year, I presented you guys with a fee schedule.
Right.
And, that was passed in and voted. And that spells that out actually in the fee schedule, initial fire inspection, secondary, tertiary, so on and so forth. So yes, ma'am, that's what that's referring to.
So I think we need to update that language to finish that sentence. Whether it will be based on the fee schedule or whatever, because that's just that's a incomplete sentence there.
Yes, ma'am.
And then my only other thing is, I noticed that we've changed that we're gonna notify people by digital report, but then over on procedure for designated fire lanes and things like that, we are requesting a written response. I would like, are you gonna only do it digitally? Can you print it off and give it to people? I mean, some people are still not up to technology now, so, if we just rely on them receiving their information by email, if we want them to give it to us in writing, we should give it to them in writing.
So that's just a mishap on my part. They can still be provided by paper, but I just want everyone with the understanding that we have switched to an RMS system that we do pay for. Paper's cost effective, and it can be printed out if needed.
Thank you. Thank you, thank you.
You good?
That's all of mine.
Then, question. The issue that Ms. Finney brings up in regards to completing the thought or the sentence, Mr. Attorney, do we need to table to get this corrected?
We can.
Or can we construct the sentence?
If you want to go ahead and construct it, you can do that tonight
All right.
also.
Okay, we'll get to that in just a second. Hang tight, Cameron. Any other questions? Okay, please.
So when you go out and just do an inspection of a business, I guess a couple questions. I know one of your focuses has been trying to get all the businesses inspected. How many do you have left to do?
Many. I don't have an exact count. I wasn't prepared for that question to a T, but we do have many. It's no secret we are behind on fire inspections, but that's no different than anyone else in the state. We have rectified and made changes to our office to make sure that we're out there doing the work that we're supposed to be doing and doing it correctly.
Okay. So has there been any education to the community that says the fire marshal's office is going to be coming at some point to inspect your business?
No, technically by the administrative code, we don't have to give any notice or anything like that now. That's not how I like to conduct the business, but we are working through our website and with several other folks throughout our agency to get something more educational, not only to go on our website, but, for us to be able to hand out to folks as we do the inspection.
I would like that, ever how we can educate the public, because I have got a couple calls of people where you've showed up and did your inspection, which was proper, but they were like, I've been here 30 years. I've never been inspected. And it was just kind of a surprise. They got no issue with the inspection, and I think that makes sense from a safety standpoint, absolutely. But if we could, I don't know how we do that. The website's a good idea, but if we could educate the public and let them know that that's part of your purview and you will be executing on that, I think that would be good.
Sure. So not only the website, but as technology grows, we're also looking at developing an app, something informational. Again, we're trying to speak with these folks. My guys are pretty well trained on asking specific questions regarding, an inspection and moving forward with that inspection. The questions are always asked, the introductions are made first. Secondary to that, is there, anywhere we can't go, somewhere we might need some supervision? And then, towards the end, hey, do you have any questions about your inspection? Try and point things out. So we're finding our way with that. You're right. 30 years is a long time to go without an inspection, not to see us. It's a culture change.
That was an arbitrary number, but the point is, they'd been here a while. So anyway,
Absolutely.
okay, thank you.
All right. Any other questions? All right, Mr. Vogler.
Chair has announced this is day and hour of the public hearing pursuant to North Carolina General Statute and Davie County Code of Ordinance of amendments to the Fire, Rescue, and Protection Ordinance of Davie County. There has been due notice given pursuant to the requirements of North Carolina General Statutes and Davie County Code of Ordinance by way of due publication of notice of the public hearing in a newspaper of general circulation in Davie County. The clerk has attached an affidavit showing publication in the paper as part of your packet. I would ask all who wish to comment at this public hearing to come forward to the podium, state your full name, and then comment. Mr. Chair, seeing no one come forward, I would now turn the public hearing back over to you as board chair, to close the public comment section of this public hearing, provide the board the opportunity to discuss among yourself what, if any, action you wish to take with regards to this matter.
Okay. Motion to close the public comment. Mr. Poindexter, do we have a second? Second. Okay, Mr. Shove. Any discussion on that? Okay. All in favor? All right, now, we need we have some correction we want to make on.
What page was that on?
So it's on page 8,
It's page 8, okay.
and it's number 3 under fees, costs, and penalties.
Well, mine's froze up now.
Initial inspection of permitted work, and then it says upon initial inspection of permitted construction or operation, comma, it used to read, no inspection fee shall be assessed, but now we have the fee schedule, so what is the best language there? Fees will be based upon the fee schedule?
Fee schedule.
I mean, is that,
Works for me, yeah. Simple.
Yeah, you've already adopted a fee schedule, so
Yes.
all fees should be based upon your fee schedule previously adopted.
so upon initial inspection of permitted construction or operation, comma, fees will be based upon approved fee schedule?
That's right.
Is that
That
appropriate?
would take care of it.
Posted, yeah.
Post, yeah, whichever. Well, I don't know if it's posted, but approved fee schedule. That way it could change and that would still be
From year to year.
effective.
Good?
So you need to make
Does
a
that work?
motion.
Is that?
All right, let's
Amend
have,
that.
we need to have a motion to amend the wording.
Okay.
Do I have that?
I'll make a motion that we amend the wording to complete the sentence under 91.33, item number 3.
Okay. And Ms. Logan, you've got that?
Did you
Okay.
get what I said? Good, because I don't know if I remember it.
All right, do we have a second on the amendment? Okay, Mr. Schoaf, all in favor of the change in wording? Okay. Now, do I have a motion to approve the ordinance?
I make a motion, we approve the ordinance changes.
Chair, have we had the public hearing?
We closed the hearing.
We closed the hearing, okay.
Yes, sir.
Okay.
Ms. Finney makes that motion. Do we have a second? Mr. Reniger seconds. Any other discussion? Okay, all in favor? All right, thanks, Cameron.
Thank you.
All right, now, item 6, text amendment.
Thank you, Chairman, Commissioners. Today I present subdivision text amendment in reference to our subdivision ordinance 15442. The amendment we're changing is for the lot size and dimensions in major subdivisions. As it currently reads as on there, and I won't read everything, but C is what it's going to affect. These are just for major subdivisions. Lots shall comply with the following requirements. What's currently stated, lots served by both public water and public sewer shall have an area not less than 8,000 square feet, a width at the building line of not less than 70 feet, nor be less than 100 feet depth. Planned unit developments are exempt. Lots served by public water but not public sewer shall have an area not less than 3,000 square feet, a lot width at the building line of not less than 80 feet, nor be less than 150 foot deep. Planned unit developments are exempt. 3, lots served by neither public water nor public sewer shall have an area not less than 40,000 square foot and a lot width at the building line of not less than 100 foot and not be less than 100 foot depth. So this is the addition, the text amendment, what we're asking for. All lots in a major subdivision that are accessed by a public, dedicated, or maintained street shall meet the following requirements. The lot width, 150 foot, shall be the minimum width of each lot. Measurement shall be made from one side property line to the other at the building and at the building setback line. Front yard setback, 60 foot shall be the minimum setback of the principal structure measured from the nearest point of the building and the right-of-way line. 3, the side yard setback, 30 feet shall be the minimum side yard setback for each principal building measured from the nearest point of building and lot lines. So that is the proposed text amendment. This came about from various public meetings throughout the county with developments and addressing some of the concerns with some of the lot dimensions and lot widths associated with new building here in Davie County. This was unanimously approved on the January 3rd Planning Board, and this only affects major subdivisions. So if a developer comes in and is developing lots, and the lots abut a public dedicated or maintained street and they access it, that's the minimum lot depth that they will have and dimensions of the lot. A minimum major subdivision is defined as 3 or more lots. So I'd be more than happy to address any questions this board has about this.
Any questions or comments?
Johnny, could you clarify for people that kind of what it really is changing as far as from the minimum to what's being done now and the part about the being a dedicated street maybe versus like if somebody did a subdivision, so that might be a question someone might have.
Sure. So as it's stated right now, this only addresses when a developer comes in and they're developing a piece of property. Any road where the developer constructs or builds a road coming in, a cul-de-sac or road interior that they're building, this will not affect any of those. The lot widths will still be whatever it is in the existing subdivision, the design requirements of those. This only addresses lots that if the developer is going to access them off of a publicly dedicated or maintained road. So the lots, if there's an existing Smith Road, Smith Street, just a generic road, if the developer in a major subdivision chooses to access those lot widths, the lot widths have to be 150 foot wide. It's only addressing the lots that are accessed off of a a public dedicated or maintained street. If the developer is constructing or building roads in it, it does not change that. The minimum setback will still be the same. So the minimum lot width is what we have now is 25 foot wide, okay? So we get those, we see these a lot of times in cul-de-sac lots and stuff like that. The building front line sets back, but that is in this ordinance. The minimum lot width could be 25 foot wide. So it will not change the design or developer other than the lots that are accessed off of a publicly dedicated or maintained street.
They got you, Brent. Okay. Any other questions?
Just by way of example, if you had a developer that had a lot with 500 feet on, pick a road, Smith Road, the effect of this would be, they would be going, if you had 100 feet width lots, they would be going from possibly 5 lots to 3 lots.
Correct. Unless they decided to build a cul-de-sac road in those and access those off of those, then the lot width, they could get as many lots as they wanted to out of those. As designed, the minimum square footage would still have to be maintained. The majority of the county is the 40,000 or 30,000 square foot. We have less than 1% in the county, under the county jurisdiction, that have access to municipal sewer, which is R8 and R12. We see mainly RA and R20 lots, so it's the 30 and 40,000 square foot lots. So yeah, that would be correct. And I did receive a call from a developer this morning to get clarification. Apparently there was a little misconception in the paper that we were going to, all lots would now be 150 foot wide. It's just lots that access through a publicly dedicated or maintained street. And the developer alluded to me that this is the trend throughout. Some of the surrounding counties are doing this to combat these narrow lots and some safety concerns on accessing through some already major roads.
What qualifies a subdivision to be considered a major subdivision?
3 or more lots. Yeah, and those, there are examples, there are exceptions with that. If, Commissioner Reniger, if that person proposed that and they were going to be subdividing property for their family, okay, that is an exemption. You can create more for family property if you will it to family. So that there's exemptions in this. There's ways around that. So but a major subdivision is 3 or more lots.
Any other questions?
Can I comment?
Sure, yes.
Comment here would be just to make sure people are aware, this is not to be punitive. The main impetus behind this is safety along with aesthetics and not having these developers come in and circumvent the spirit of the 30,000 square foot, because what was happening is you were had people call me, go, well, I've got a quarter of an acre lot across from me, and I'm like, how? You live in the county, that doesn't have sewer. And they'd say, well, this lot's only about 80 foot wide, but what they were doing is they're doing 80 foot and then they're going 300 or 400 foot deep, only really in action developing that front portion. It's kind of like what you've seen if you live in these areas like on 801 South, Sheffield Road, Bailey's Chapel Road. There's some more like this, but you end up with sometimes shared driveways, sometimes very narrow, and at 55, 60 miles an hour. So that's kind of what we're trying to do, not trying to upset the spirit of a subdivision built on a cul-de-sac and get away from what Johnny clarified.
Okay. Any other questions? All right, Mr. Vogel.
Chair has announced that this is the day and the hour of the public hearing pursuant to Chapter 160D of the North Carolina General Statutes and also Chapter 155 of the Davie County Code of Ordinance of an amendment to the zoning ordinance regarding Section 154.42 and the requirements for lot size and setbacks. There's been due notice given pursuant to North Carolina General Statutes and Davie County Code of Ordinance by way of due publication of notice of the public hearing in the newspaper, general circulation in Davie County. The clerk to the board has attached an affidavit showing publication in said paper. I would ask all who wish to comment at this hearing, come forward to the podium, state your name, and then comment on the proposal. Mr. Sayre, seeing no one come forward, I will now turn the public hearing back over to you as board chair to close the public comment section of this public hearing, provide the board the opportunity to then discuss among yourselves what, if any, action you wish to take with regards to this matter.
Okay. Do I have a motion to close the public comment? Ms. Poindexter, do we have a second?
Second.
Ms. Finney, any further discussion on that issue? Okay, all in favor? All right. Now, do we have, we'll need a motion to approve the ordinance, the text amendment.
Make a motion to approve the text amendment.
Mr. Shove, do we have a second?
Second.
Ms. Finney, any further discussion or questions for Mr. Easter? All right, all in favor? All right. Thank you, Mr. Easter. Thank you. All right, public comment period.
Mr. Chair, as far as the rules, of public comment, we're up at front. However, I will go back over some of those. As you come to the podium, you need to state your full name so that Madam Clerk can get your name in the minutes. You have 3 minutes to speak. I will be holding up time cards at 2 minutes, 1 minute, 30 seconds, and then time to stop. And I've been designated as timekeeper by this board to do that. There'll be no exchanges, verbal exchanges between the board and members who comment. And other than that, we've got 3 people who've signed up. First one is Jennifer Riddle.
Good evening. I'm Jennifer Riddle, and my husband Arnie Riddle and I live at 1640 Farmington Road. Last month, we came and updated you on the state of our settlement agreement with Davie County and the state of North Carolina, which was signed on June 8, 2023. 8 months later, we still do not have our payment. Thank you for hearing our comments last month. We also want to thank Ed Vogler for his efforts since then to try and help resolve this. Ed has enlisted the help of Representative Julia Howard, who has also been trying to help us. Considering that our settlement continues to be passed around Raleigh for some reason, even though it is a completed legal agreement, we have a suggestion. We think Davie County should provide us with the full settlement amount, and then you can fight Raleigh to get your funds reimbursed. We're now in year 5 of this ridiculous situation, and we're now ready to put it to rest. We also want to clarify some details about our experience with the Davie County Environmental Health Department. In 2014, at the age of 60, Arnie contacted Davie County to see if his lot would perk, and he received a septic permit for what would be the front yard. From April 2015 to June 2016, Arnie cleared trees and built a storage shed. He did this work himself. In June 2016, Arnie requested and received a Davie County septic permit for the backyard. From June 2016 to January 2020, Arnie built his house himself while working full-time. In February 2020, Arnie called his septic system installer and asked him to prepare the lot for installing the approved septic system. The 2016 permit was still active for 17 months. Without telling Arnie, the installer called Brittany Mitchell in the Davie County Environmental Health Department, and they met at the property without Arnie with the intent of reevaluating the soil. Remember, our house was built. They dug holes, and we were told that Brittany said she didn't like how the soil looked, so she called Kevin Neal from the North Carolina Environmental Health Department. On March 13th, Arnie met the installer, Brittany, and Kevin at the lot. Shortly after that, Kevin told Arnie that he had revoked Arnie's active septic permit and that Arnie and I may not be able to live in the house at all. We never received written notification of the revoked permit. It goes downhill from there, and I have 3 short points I want to conclude with. First, 2 independent soil scientists evaluated our backyard, and lo and behold, it perked. So the former DC employee was correct in his assessment of the soil. Second, even though the Davie County Environmental Health Department is operated by the state, most people don't know that, and they think it is a Davie County department, so they associate the dealings of that department with Davie County and you. And third, it's a very sad statement that for the past 4 years, if I hear someone say they hope to build a house in Davie County, I say without hesitation, whatever you do, don't call the Davie County Environmental Health. Call an independent soil scientist. It will be well worth the money you pay versus any Davie County evaluation. Please consider our suggestion for the settlement payment. Thank you.
Next, we've got Joe Everett Jr.
Jody, most everybody knows me. I am currently running a website, stopalloffaiththere.com, opposing a zoning request. The zoning amendment number is DC 2408006, submitted by Brad Rye. But I'm not here tonight to talk to you about that specific request. I am, however, here to talk about some of the ways that this board, the planning board, Mr. Easter, and the public of Davie County could potentially improve the situation with the rezoning in Davie County. In reading back through years' worth of minutes of this board, the most contentious items that seem to come before this board are when we have rezoning requests from residential to commercial, which happen quite frequently, multiple times a year. I think there's some ways that the planning board, Mr. Easter, and this board could help build some trust with the public in general. Just going to highlight 6 and I'll be done. The plan, we've talked about this, you guys have already highlighted this previously tonight about getting the message out to the public besides just the enterprise, mail, et cetera. If those plans were presented to the public prior to the zoning meetings, that would go a long way in building some trust, rather than having to chase somebody down, exchange emails. Maybe the attachments come through, maybe they don't. If those could be posted. Recording of the adjoiners, either support or opposition. That's not intended to be a veto of it. I've spoken before this board, both in opposition and in support of commercial things before, but to have that be recorded, at least for adjoining landowners. Asked that adjoining landowners be given more than the 3 minutes of time that the general public gets. I think that's a fair approach. Somebody that's got some vested interest in the proposal one way or the other should have more contention than somebody they just bought a house from prior. 5th, topographical data presented to the board for their consideration. The current packets do have a lot of two-dimensional data, some aerial overheads, no topographical data. In my particular situation with this one, I think that would be very helpful for some of the board to understand. 5th, a quorum of the board on the ground at the proposed site. This is not an indictment of the board. There were some board members of the planning board, and this decision is currently deferred, by the way. There were some board members that actually come out and take a look physically at the site. I think that ought to be at a minimum a requirement for any new residential to commercial rezoning requests. And then 6th, a review of available sites available currently to the applicant. I hope our land use plans encourage use of existing sites and that we're not just willy-nilly rezoning additional sites while current sites are set vacant. So that's all I had. Thank you.
And then last, we have Steve Lowe and Teresa Smith. They've signed up together. I don't know, are both of you going to come up and speak? Or
Actually, we were interested in a parcel of land that's not under discussion tonight, so it wouldn't be germane to your.
Okay. And that's all we have signed up tonight.
All right. Brian, do you have a presentation to make, or are we going on to Rob?
We're going on to Rob.
Okay.
I think that's
All right, Rob.
covering Rob.
Yeah.
Good evening. I'll be very brief. This is the same report that I covered at our budget retreat. So this compares the current year, December, through last year's December. For revenues, it's basically the same amount that we had last fiscal year at this time. Some differences are some timing and tax rate collections. At the end of December, we had about 75% versus a little over 76%. That's just because some large taxpayers decided to wait until January to pay. As far as expenditures go for the general fund, we have about $727,000 more of expenditures, mostly due to the counting of contributions made to other funds for capital projects, as well as the fire fund. Just as a frame of reference, our December year-to-date revenues are about the same, so about 54% of our estimates, and expenditures are 42% of our annual budget appropriation, which should be about 50% since we're halfway through the year. Let me know if you have any questions.
Any questions or comments?
Thank you.
Thank you, Robin. All right, County Manager's report.
Thank you, Mr. Chairman. I have 2 items that I want to report on. This upcoming Wednesday,
February the 7th, our Cooperative Extension Department will be hosting their annual soup fundraiser for the ECA Scholarship Fund, starting at 11 a.m. and going to 1:30 at their offices at 642 Wilkesboro Street. And the second item I'd like to report, through the effort of the Sheriff's Office, we have reinstated our K-9 division in a very cost-effective manner. We actually had a K-9 officer come to us. So that just goes to show that out there in this world that more people are looking at Davie County. So I'm glad to report that that's back in operations. That's all I have tonight.
All right, we're on to the consent agenda. Do I have a motion to approve the consent agenda?
So moved.
Is that Mr. Poindexter? Mr. Poindexter, do I have a second?
Second.
Ms. Finney, any discussion in that regard? Okay, all in favor? Any opposed? All right. Item 11, any old business? Any new business? Okay, commissioners' comments. Mr. Schoaf, if you want to start us off tonight?
As always, I'd like to thank everybody for coming out and speaking and being here to witness the meeting as we conduct business. Really don't have much more to say, but I'll just go ahead and make it brief. Thank you.
Anita, you want to go ahead?
It's up to you.
That way I don't forget you.
Thank everybody for being here tonight. We always like to have a lot of people here. Last Thursday night, Davie County had a point-in-time count, which was an event that was to count our homelessness or our struggling people in the county, and we had a lot of county employees who came out and were a part of that. We had Karen and Rachel from the library, of course, our community paramedic, people from social services, and we just had a great response from county employees to come out to that event. And we didn't have a ton of people, but we made a difference that night. There were some people that some wonderful things happened to, whether it was just find out some resources that were available to them, or actually make the decision to go somewhere and receive some treatment. So it was an awesome event. We also had like Family Promise, the Advocacy Center, Old Vineyard, NAMI, and Serving Our Neighbors. We served a meal. It was great. I'll thank all of you who all were there, of county employees that were there. And I hope that we can do some more events like that so we can let our folks know what is available to them, what we can help them with. And the library had a sale this week, and they had a very successful sale. I almost missed all the good books because I got there late, so it was great that they sold a lot of books. And I want to briefly share, on Wednesday, we have a great opportunity, and I'm so thankful to Suzanne for being willing to host this opportunity. We have Ms. Tara Tucker, who is a lead behavior health community paramedic in Cape Fear Valley Mobile Integrated Health. And she's going to come here and do a little presentation and discussion with some of our social service workers and health department workers and community paramedics. I'm very excited about that. She brings a lot of experience to the table. I think it'll be a great conversation that will just be beneficial to everybody. We might tell her something she doesn't know, so. And then I just want to take a minute to congratulate all of our young people who are doing great things in athletics in the last few weeks. Our wrestling team are state champs. We've got track members that are state champs. Our cheerleading team is going all the way at Davie High School, and Tom Cowden shooting sports teams are state champs. We have a lot of young people in this county that are really doing some great achievements and working very hard to be successful, and I hope if you get the opportunity, you'll support them. Thank you all for coming. Have a great night.
Richard?
Thanks, sir. It's always nice to look out in the crowd and see the usual faces, but it's even nicer to see some of the new faces of people showing up. I would like to take the moment to say thank you to all our county employees and all our people in the county that help us in every different way. We have so many volunteers in this county. It's absolutely awesome. That's what makes Davie County what it is. I guess I'd be remiss if I didn't say everybody needs to remember Valentine's Day is coming up and need to remember your husband, wife, or your significant other. Thank you for coming out tonight.
Thank you. Appreciate everyone coming out, as always, and appreciate the input. We are paying attention to the input and may not think that sometimes, but we are. So we thank you for that. And I wanted to shout out to Benita. I'll follow up what she said about the state championship, or the state champions we got in the various sports. That's awesome. So that's can be commended. So please come back next month. Thank you.
Thank you all for being here. Mayor Smith, thank you for being back with us from Coolamy again. We really appreciate it. And we always thank you for your input. And thanks to each of you for being here. Do we have anything else? All right, do we have a motion to adjourn?
So moved.
Ms. Finney, she got you this time. Richard second, all in favor? Okay. All right, we stand adjourned. Thank you all for being here.